Hello, everyone. Thank you for your patience as we worked on this unusual event, at least for us here at the Opera House. I'm pleased to welcome you all here to the 27th Court Community Connections Program. My name is Owen Goslin, and I'm the Executive Director here at the Cheboygan Opera House. And we're pleased to have so many school groups here today, from Traverse City to Rogers City, St. Ignace, and of course Cheboygan. It's just such a wonderful opportunity to have the court here for this historic occasion. It is historic because although we have been here at the Opera House since 1877, there's been an Opera House in Cheboygan. We've had all sorts of different historical figures here: Thomas Edison, Annie Oakley, the John Philip Sousa Band, Mary Pickford. I could go on and on. We have never, however, had a court session. So we are here for the first time with the Supreme Court. It's really amazing that over a long history we can still do something new. And to mark this historic occasion, would you all mind joining me in a selfie? Would you put on your best smiley face? I'm going to have Lindsay Horrick come up here. We can't let this go past. So if you could just take a moment. 1, 2, 3, cheese. Come on, say cheese with me. 1, 2, 3, cheese. Thank you. Thank you, Lindsay. And thank you for your cooperation. It's great to have the court here. I do want to take a moment to remind you that if you have a cell phone with you, please turn the cell phone off during this session. We have a program that you see in your, you have your printed program here with the events that we're going to have. I also want to just remind you that if you could be respectful of the speakers, quiet, have your full attention on the stage, that's always appreciated. And I think at this point, I'd just like to say thank you to all the people who made this possible for Cheboygan. I'd like to thank the Supreme Court and all the staff who helped make this come together, including Raven Gilmore, my contacts, and of course our local judges, Judge Aaron Gothier and retired Judge Robert Butts. Thank you so much for all your hard work in making this possible. So if you would join me in standing for the posting of the colors and remain standing through the Pledge of Allegiance. Please come forward.
Detail. Post color. We will now say the national anthem. Detail. And salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Order. Arms. Dismissed.
Good morning. Thank you to our local veterans for providing a color guard and leading us in the pledge this morning for this special event. In 2021, Cheboygan Veteran Service Officer Sarah Cunningham, who's with me on stage, instituted a program to recognize local veterans that are making a positive impact in the community. This program is the Hometown Hero Award. A committee evaluates nominations and selects a monthly recipient. as well as an annual award winner. Committee member Joseph Longstreet is also present on the stage with us. Local media provide coverage of the award, which highlights the ways that so many veterans continue to benefit their community even after their military service has ended. 19 local veterans have so far been honored as the Hometown Hero of the Month. And today I'm privileged to announce the recipient of the 20th Hometown Hero Award. The certificate reads as follows. As an Army veteran, you continue to serve in a selfless manner throughout this community. You are an active member of both the Cheboygan VFW and the American Legion. Every year you help organizations with their poppy sales and other fundraising events, even organizing and running the VFW's golf tournament. You have volunteered as a member of countless military funeral details throughout the county, honoring hundreds of veterans over the years. You also spent several years as a volunteer driver for the county's DAV transportation program. You're on the board for the Cheboygan County Veterans Memorial Park Committee and are a representative for the Cheboygan Veterans Subcommittee. You generously offer your time to deliver food baskets to local veterans in need during the holidays and are the first one to offer help when a veteran is in need. Your service to your fellow veterans and to this community has been exemplary and has set the bar high for others to follow. This certificate is, of course, describing Color Guard member Michael Donovan, who is the Hometown Hero for May 2023. The men and women who serve in our nation's military stand guard not only over our nation's colors, but over its very freedoms. And one of the cornerstones of that freedom is the rule of law. The idea that disputes are resolved and criminal justice is administered by the equal application of the law, not by popularity contest, vendetta, or mob rule. So our court system is designed to protect the rights of all people, including victims of crimes and people accused of crimes. There are many trial courts spread throughout the state to handle everything from traffic tickets to civil lawsuits to family law matters to murder trials. We also have a court of appeals because judges are human and sometimes make mistakes. And atop this court system is the Supreme Court, the court of last resort on matters of state law for 10 million Michiganders. And today we are honored to have that Michigan Supreme Court hold a session in our community and to watch its work firsthand. When I was a practicing attorney, I had the privilege of arguing 3 cases to the Michigan Supreme Court. Each time, I was impressed at the care and attention the court gave to my case, sometimes a little too much attention during the questioning, in fact. And any attorney presenting a Supreme Court argument spends many, many hours preparing the case and anticipating possible questions. So we are all in for a real treat today to observe the highest court evaluate well-crafted arguments in a case that has implications for many other cases throughout the state. But since this is an actual session of court and not a concert or recital event, please do refrain from any reactions or applause, even if you think one of the lawyers makes a particularly good point. So I'm so glad to see so many area schools participating in the session today, including a question and answer time afterward with the attorneys and the Supreme Court's Chief Commissioner. This is a great opportunity for our students as well as our community as a whole. At the northernmost tip of our county sits the mighty Mackinac Bridge, connecting the 2 peninsulas of our Great Lakes state. What some of you might not know is that one of the men instrumental in the creation of that bridge was an Upper Peninsula lawyer named Prentice Brown. Now that lawyer once missed an argument at the Michigan Supreme Court because when he tried to get across the ice to reach Lansing, he could not. He later recalled, "That bitter hike made a lasting impression on me for the need of a bridge across the straits." So the Supreme Court had a role in the Mackinac Bridge, if you will. We're all glad that Prentice Brown's vision became reality, but I'm pretty sure he would have been excited to have seen the Supreme Court venture out of Lansing to hold court in different locations throughout the state, including northern Michigan. This is, in fact, the 27th time the Michigan Supreme Court has left its hallowed halls to hold court in a local community. I'm grateful to the Opera House, its executive director, Owen, and the Cheboygan Arts Council has graciously provided this beautiful forum for this historic event. As we will soon begin the court session, I would remind you to please turn off any electronic devices that you may have and attend to the proceeding with respect. At this time, please be seated and remain seated as we invite some area judges to enter the chamber to take their seats. Joining us today are Court of Appeals Judge Allie Greenleaf Maldonado, Cheboygan Probate Judge Darrell Visnaw, Presqu'île Probate Judge Eric Stone, 89th District Judge Maria Barton, retired Cheboygan Probate Judge Robert Butts. And so soon, the Michigan Supreme Court crier, Jeff Mills, will open our court session.
All rise. Hear ye, the Chief Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning, everyone. Before I call today's case, I'd like to take a few moments to thank our hosts and welcome students and educators. I have been told we're at building capacity. Close to 400 students are participating today here in the historic Cheboygan Opera House. We have students from Bishop Braga Catholic School, Cheboygan High School, Cornerstone Christian School, Gaylord High School, Inland Lake Secondary School, Inverness Academy, LaSalle High School, Mackinac City High School, Northern Michigan Christian Academy, Onaway High School, Presqu'île Academy, Rogers City High School, Traverse City West Senior High School, Vanderbilt Area Schools, Wolverine Community Schools, as well as several homeschooled students in the area. My colleagues and I very much appreciate the opportunity to join you and to highlight our commitment to community engagement, to accessible and open courts, to independence, and to efficiency. Thanks to the Cheboygan Opera House, the 53rd Judicial Circuit Court, Cheboygan Presqu'île Bar Association, attorney mentors, students, educators, and community members for your support. The court appreciates all of your efforts. Without our local partners, the Supreme Court could not have the Court Community Connections program. This is the 27th such program for the court. As is the case with all these events, the court is very much dependent on the local bench and bar for their support and cooperation. I have had the opportunity to be part of several programs, and I think this is the best venue I have seen, so thank you for this experience. I'd like to add a special thank you to Chief Judge Aaron Gauthier and former Chief Judge Robert Butts for your help and hard work has been absolutely critical in making this vision of Court Community Connections in Cheboygan a reality. I also want to express my gratitude to Chief Judge Gauthier for his leadership on the Michigan Judicial Council, where he is chairing a work group developing recommendations for live streaming of court proceedings to YouTube. I commend the judge for his commitment to transparency and regularly live streaming to YouTube. I am told he receives thousands of views of his weekly streams and that he may have better ratings than Judge Judy. I I thank former Chief Judge Robert Butts, who provided the impetus for today's gathering of the Supreme Court. In 2019, he attended our oral argument in Sault Ste. Marie and felt inspired to bring the Supreme Court to Cheboygan. He approached our staff last year, and after months of planning, this was born. There aren't enough kind words I can say about Bob as a host. It is a privilege to know someone who cares so deeply about their community like Bob does. It is truly inspiring. I'd like to acknowledge the other judges present today: Court of Appeals Judge Allie Greenleaf Maldonado, Cheboygan Probate Judge Daryl Visna, Presque Probate Judge Eric Stone, and 89th District Judge Maria Barton. Last but not least, thank you to the Michigan Supreme Court Security, the Michigan State Police, Cheboygan Police Department, and the Cheboygan County Sheriff's Office for all of their assistance today. Today's oral argument is being live streamed so viewers can watch anywhere in the world. So welcome to everyone watching the live stream. And while you're online, make sure to follow the court on Twitter, Facebook, and LinkedIn. A couple of housekeeping items. First, with the exception of the media and the professional photographers, no one should take photos once oral arguments begin. There will be plenty of opportunities for photos during the reception. Second, if you have not already done so, please turn off all cell phones for the remainder of the proceedings. Following oral arguments, please remain in the courtroom for the debriefing with counsel for the parties. This year, we have Michigan Supreme Court Chief Commissioner Dan Brubaker as the moderator. The commissioners and law clerks who work for the court are incredibly talented, and we wouldn't be able to do our work without their tremendous assistance. So we are very proud to have Dan here after the argument to talk with the attorneys while the court conferences on the case. Oral argument is a key part of the appellate decision-making process because it helps determine the outcome for the parties in the case and may affect the outcome of future cases that lower courts are bound to follow. By the time of oral argument, the justices are very familiar with the case. We've read the parties' briefs and the lower court record, and we've studied the legal issues. The questions we ask during oral argument and counsel's answers do help us reach a decision, but more importantly, they can help us, if we decide to render an opinion in the case, to craft an accurate and clear statement of the law. Like us, you have already studied this case. You know what the issues are. You've come to today's hearing with questions you would ask if you were a justice. And when the court issues its decision, you will get to analyze our ruling and decide whether you agree or would have done things differently. So our goal is to leave you better informed about the rule of law and its role in our constitutional republic. My hope is that as a citizen of your community, you'll remember this experience. Our form of government can only survive if its citizens stay informed and involved. I now call our case for the morning, People versus Candace Guyton, docket number 163700. This is a 15-minute mini oral argument on the application. Good morning, counsel.
Good morning, Your Honor.
You have 2 minutes of a free fire zone that you may waive, and you may also reserve time for rebuttal if we don't use it all up with our questions, and we ask that you keep track of your own time, and please begin when you're ready.
Thank you, Your Honor. Good morning. May it please the court, Maya Menlo appearing for Candace Guyton. I'm joined at council table by Jessica Zimbelman, also the State Appellate Defender's Office. I will attempt to reserve 3 minutes for rebuttal, and I will keep my own time. In exchange for a plea bargain, Ms. Guyton gave up her fundamental constitutional rights, including her right to a jury trial, her right to confront the witnesses against her, and her right to be free from self-incrimination. When she made that life-altering decision, Ms. Guyton believed that she was facing a guidelines range of 51 to 127 months in prison. This was because the prosecutor had incorrectly charged her as a third habitual offender, when really she only had 1 prior felony conviction and was subject only to be charged as a second habitual. The guidelines range for a second habitual was 51 to 106 months, which is almost 2 years less than the range for a third habitual. Panels of the Court of Appeals have repeatedly held that if a plea is induced by a promise to forego a sentencing enhancement when that enhancement is not warranted, somebody like Ms. Guyton is per se misinformed as to the benefit of her plea. But in this case, the Court of Appeals went in a different direction. The panel acknowledged on page 4 of its opinion that Ms. Guyton did not receive the benefit of the bargain she thought she had struck. But because Ms. Guyton received some benefit for her plea, the Court of Appeals nevertheless affirmed. When we're talking about a person's liberty, Getting anything less than what she bargained for was not knowing, was not understanding, was not accurate, and was a violation of her due process rights. This court should vacate the Court of Appeals opinion and hold that a person who is ineligible for a sentencing enhancement may withdraw their plea, where dismissing that enhancement was part of the plea bargain. Or a more broadly applicable rule would be, if a prosecutor's error affects the value of the plea, then the individual should have an opportunity to withdraw it.
Counsel, is there a difference between a plea that is not knowingly and voluntarily made and a plea that is illusory?
Illusory, Your Honor, has been seen as a subset or a type of not knowing and not voluntary plea. And there are conflicting definitions of illusory that the Court of Appeals has used almost interchangeably. And so that's why, in addition to the knowing, voluntary, and the due process issue, I did raise the illusory issue for this court to consider if this court would wish to resolve those conflicting
But your
definitions.
application specifically says that you're not claiming that it is an illusory plea.
Your Honor, at the time that perhaps the application was filed, definitely at the time of the Court of Appeals argument, the definition that I was familiar with of illusory was one that is one of the definitions used by the Court of Appeals. But upon further review, there are multiple definitions, and this court used one of those in Stovall, most recently in July of 2022, and yet didn't address the other conflicting definitions of illusory. So this case does not turn on whether the plea was illusory, but should the court wish to address it, the parties have briefed it.
So in your opinion, illusory and not knowing, they're separate?
They are separate. An illusory plea is not a knowing plea, but a unknowing plea is not always illusory.
Was there a sentence cap in this case, in the plea agreement?
There was an agreement to a sentence within the guidelines range.
And the agreement also said that the range would be, 51 to 85 months?
That was the agreement. Those were the guidelines as calculated at the time of sentencing.
Didn't your client receive everything she bargained for, and in terms of the sentence that she thought she was going to get when she received a minimum sentence of 84 months?
So what we know about the plea bargain is that Ms. Guyton was aware she was being charged as a habitual third offender. She waived her constitutional rights in exchange for that enhancement to be dismissed.
Let me jump in. The question in this case is, she was charged as a habitual third, but she actually only had one prior felony?
Correct.
Of all the people in the world, you probably know how many felonies your client has. Wouldn't your client be in that category?
I'll answer that question in two parts. One, the law does not put the onus on Ms. Guyton to sit and wave her hand and try to interrupt proceedings to object to the prosecutor's charging decision. The prosecutor here had all the power and all the information to make the charging decisions.
She certainly had the right and maybe the responsibility to challenge the habitual notice if it was incorrect, did she not?
That may have been something that her attorney had the responsibility to do. This was not raised as ineffective assistance of counsel because it doesn't need to be. This was an error that is supported by the record, and the record makes clear that the parties here were pleading or entering into a plea agreement in reliance on a mistake.
Is it your position that any time a defendant is unclear about exactly what the penalty is and all of the nuances of that go into that determination, any small mistake would entitle a defendant to have a plea set aside?
No, Your Honor, this court and the Court of Appeals has developed a substantial compliance requirement for MCR 6.302B through E. And so, for example, if the court forgets to place the person under oath before they plead guilty, or the court forgets to state the charge, but the prosecutor has already stated the charge, when there are violations of B through E, subsections B through E, there is a de minimis analysis that's done. But we don't ask whether the plea was substantially knowing or substantially voluntary or substantially accurate. That's MCR 6.302A. And here, where we have shown that the plea was not in compliance with due process or MCR 6.302A, reversal is required. So in that situation, yes.
That's sort of the question we're here to decide, whether due process was complied with. And the question I asked is it an all or nothing venture? In other words, if your client receives substantial benefits from this plea agreement, but maybe not everything, for now, us, granting your position that your client somehow shouldn't be held to be aware of her own prior record, accepting that position, your client still received substantial benefits from this plea agreement, and she received the very sentence she thought she was receiving. In other words, this isn't a case where the defendant pled guilty expecting one sentence and got a much longer sentence. Here she got exactly the sentence she was expecting. And there were some other benefits, right? She had another armed robbery charge that was dismissed. That's a substantial benefit. Another major life felony charge was dismissed. And she also didn't receive any habitual offender enhancement. So it didn't go from third to none. It actually went from second to none, but there was still a benefit there. Why isn't that enough for us to sustain this plea agreement?
The location of the error is important here. The error happened at the time of charging, and it then infected the plea negotiations. Plea negotiations could have gone differently if she had been charged properly. A third habitual offender is seen as more culpable, more dangerous, more of a recidivist than a second habitual offender. So the error occurred at the time of charging, and it infected everything up to and including the plea. This was not a sentencing error. So it is important to look at this like the court evaluates Jaworski rights. Even though an individual might know that they're entitled to a trial, a jury trial, they're entitled to confront witnesses against them, if those rights are not given to the individual before they take a plea, that plea is per se invalid. That's what happened here. There was a misunderstanding, misinformation as to the benefit of the plea, and People v. Cole, this court said that that renders a plea not knowing and not voluntary.
So counsel, so your client got this 21-month benefit when she thought she was getting, I think it was 42. Is it your contention that had all the proper facts been on the table, the negotiation could have looked quite different?
That's exactly what I'm saying, Your Honor. And we don't need to probe further into what the parties knew because it's all on the record. So we know that the prosecutor here made an error. They've conceded that. And the prosecutor had all the information and all the power in making those charging decisions and the power to determine what to dismiss pursuant to a plea. And so Ms. Guyton entered this plea agreement without full information and in fact, misinformed by the charging decision that was made.
When we're thinking about this, I mean, again, she received the sentence that she expected. So the question is whether she received all of the benefit that she thought she was getting by having her exposure reduced less than I suppose she thought it was being reduced. So what would happen in a case, say, where somebody was charged with 2 misdemeanors and the prosecutor agreed to dismiss the second misdemeanor, but the parties thought that the second misdemeanor was a 93-day misdemeanor, but it actually was only a 90-day misdemeanor. And so there was, to use your word, misinformation provided to the defendant. Is it the defendant entitled to relief in that circumstance?
I think so, Your Honor, and I know that you're trying to make it seem as minimal as possible, the difference between 90 and 93 days, but that actually could
I am only
make
to
a difference.
demonstrate whether your position, you're asking us to adopt a bright line rule, because as you know, and the students here are learning, our rulings affect not just your client in this one case, but defendants throughout Michigan in all the many thousands of cases and plea agreements that go on every day. So is it your position that any minor mistake, however de minimis it is, qualifies as quote-unquote misinformation resulting in the plea being set aside?
That is my contention, Your Honor, because to allow anything else would invite prosecutors to engage in a bait and switch and to overcharge, to over-habitualize, to induce plea negotiations with the assurance that somebody like Ms. Guyton would be later unable to withdraw their plea even once the error was recognized. Now, we're not saying that's what happened in this case, but that type of rule that certain errors or certain misinformation could be excused.
What about the other side of the coin, which is if your client was aware that this mistake was made and or her attorney, but she decided not to raise it at the time, doesn't it then become just an appellate parachute? So she doesn't have any obligation to say, hey, hold on a second, I only have one prior felony, in which case the court would undoubtedly correct the habitual notice. So doesn't your position create a wrong incentive for defendants as well?
Your Honor, it's very rare to move to withdraw a plea. Of course, the court knows that. This is not something that would open the floodgates to parachutes and harboring error and any of that. Defendants don't have this obligation. So that's the first answer to your question. But the second is that some back of the napkin math tells my colleagues and I that about 3.5% of people who enter pleas even request appellate counsel be appointed. Beyond that, we have people who dismiss their plea dismiss their appeal many times, people who seek sentencing relief only, and then in very few cases, we have people who wish to withdraw their plea. And so that's the situation we're in here, where somebody was misinformed and later says, you know what, I want to withdraw that plea because that's not what I was told and that's not what I was bargained for. So we're asking this court to reverse the court's appeal.
Your client risks there's risk to your client in succeeding, right? I mean, if she is successful in withdrawing her plea, then the other charge, perhaps a second enhancement, is back on the table, right? And so that's a decision that your client is choosing to make in withdrawing or seeking to withdraw the plea.
That's right, Your Honor. And our court rules provide that if this court were to grant relief, she'd have the opportunity to withdraw the plea. So she wouldn't be required to, but yes.
I would take exception as a former trial judge that motions to withdraw pleas are rare. What's rare is that they're actually granted. They're often brought but rarely granted. But let me just take you down a different path. When I review this case, the natural inquiry to me is whether the defendant would have accepted the plea but for not being informed of this, and that strikes me as ineffective assistance to counsel. If we go down that path, whether there's any prejudice here. And I don't see it. Why isn't this really an ineffective assistance to counsel claim?
You're right, Your Honor, that cases, United States Supreme Court cases like Lee and Padilla were ineffective assistance of counsel cases where the prejudice inquiry was whether a reasonable opportunity of a different outcome could be shown. We don't have that here. We didn't raise it that way. It's not been litigated that way. This is an error that's apparent from the record and on its face violates the court rules. So there's no need for an evidentiary hearing to figure out what she would have done or wouldn't have done or to put counsel on the stand and ask questions of counsel. That's not the way the claim is raised. And it's not required by our court rules or by Cole or other case law. I do see that I have 1 minute, and if possible, I'd love to reserve it. Thank you.
Thank you.
Good morning. May it please the court. Katie Went with the Kent County Prosecutor's Office on behalf of the people of the state of Michigan. There is no rule in Michigan that per se invalidates a plea when the defendant is misinformed about one of many benefits she is to receive in exchange. State and federal cases have demonstrated for decades that this must be a case-by-case consideration. As this court has already acknowledged in oral arguments today, Ms. Guyton received substantial benefits in exchange for her plea. She received the dismissal of a second case in its entirety charging the life offense of armed robbery. She received a dismissal of the habitual offender information and an agreement for a definite sentence or definite guidelines of 51 to 85 months. The people have never disputed that defendant was mistakenly charged as a third habitual offender rather than a second. But just as this court has declined to enforce strict compliance with the court rules and looks to a substantial compliance standard and the nature of the noncompliance, this court should look to the nature of the misinformation at issue in deciding whether defendant's plea was voluntary and understanding. Here, defendant focuses on this 21-month discrepancy in the guidelines based on her habitual offender status. But it bears mention that if defendant actually went to trial and was convicted, her PRV score could increase by 10 points, raising her guidelines to 81 to 168 months as a second felony offender. So the benefit she received is actually greater than that she's arguing today. And by pleading guilty to a sentence within these guidelines of 51 to 85 months, she received a significant benefit in not having to worry about those guidelines being rescored or any of the other uncertainties that come with sentencing proceedings. She knew when she pled guilty that she would not be charged with any sentence enhancement. She knew that she would not be facing a second armed robbery, and she knew the guidelines range for her sentence. So given all of this information, she had sufficient awareness to make an informed decision on whether to plead, and she knew the consequences of her plea. I want to focus in first.
When you say that she knew the guidelines for the conviction, Are you saying she knew the guidelines for the second, if she had been a second habitual offender?
She knew the guidelines that she would be receiving for her plea, is what I'm saying. So she knew that her guidelines would be within 51 to 85 months, and that if the court sentenced outside of those guidelines, she would have the opportunity to withdraw.
Well, you're giving us a time frame of if she hadn't pled and had gone to trial and what her guidelines would have been. But the defendant didn't know that at the time because she didn't know that she was charged as a third habitual when it should have been a second habitual.
So even with her guidelines as a second habitual, her attorney could have calculated those, scoring PRV 7 with 10 points for a concurrent felony conviction had she been convicted of both armed robberies or even an armed robbery and an accessory after the fact, depending on how the facts laid out with the jury. And in that case, if she was scored those extra 10 points, her guidelines would have been 81 to 168 as a second felony offender.
If the trial judge had said, I understand that the plea guideline range is 51 to 85, and I understand that we're dismissing the habitual, we're dismissing the second felony, but this is your third offense, and so I'm gonna score you, or I'm gonna sentence you to the higher of that range at 81 because it's your third offense. If that had been what the trial judge said, would you have a different argument here today?
I think if that had been what the trial judge had said, there would be a better argument for the defense that this wasn't voluntary. But of course, that's not what happened here. And in fact, the trial judge at sentencing did say you only have one felony conviction. And the PSI also recognized that defendant only had one felony conviction. So at a minimum, defendant was aware at the time of sentencing that this habitual offender information was wrong. And she still didn't move to withdraw her plea at that time, which, as this court knows, would have given her greater benefit because the court rules are a little bit more lenient with respect to a plea withdrawal before sentencing than after sentencing.
And what if the trial judge had said, I'm gonna sentence you to the very low end of that range. I'm gonna sentence you to 51 months. Taking all of this into consideration, assuming that it was a third habitual, assuming that that everything in the plea agreement was factually correct. Do you think that there would be a different argument here today that if it's a second, that the judge may have said, well, I was already at the very bottom, I would have gone lower, if the plea agreement had taken this into account?
I think given the facts of our case and the fact that the defendant had such a substantial criminal history with her 22 misdemeanors and one felony conviction, that would not have happened in this case. As the court justified at the sentencing hearing, that was his reasoning for sentencing her at the top of the guidelines. I think the important thing to recognize with her sentence being definite is that cases from both our state and federal have recognized that when a defendant knows the penalty that she's facing, that's the most important direct consequence of the plea for determining whether a plea is knowing and understanding made. In this case, there was no question that she was going to be sentenced within those guidelines. Because, as the courts pointed out, she knew every single benefit she was receiving in exchange for her plea. This 21 months, it might have changed the value slightly, but courts have held that even in one of the cases that's cited by the defense in their reply brief said a minor slip by the prosecutor does not necessarily invalidate a plea. We have the case from the Fourth Circuit, Hammond v. U.S., that said a mistake in a few years wouldn't necessarily render a plea involuntary. In that case, the benefit to the defendant was grossly exaggerated. And that's why I believe this court has to look case by case to determine what was the nature of the misinformation at issue. Looking at the Santabello decision by the U.S. Supreme Court, did this misinformation significantly induce the plea? And in this case, when we look at all of the facts, when we look at the substantial benefit she received, and the fact that she knew exactly what she was going to receive, or at least within a guidelines range, going into her sentencing, I don't believe that we can say
but could that negotiation have gone differently if she had known? I mean, it could have, couldn't it have? I mean, if we're just starting with a second enhancement instead of a third, isn't the whole negotiation process kind of tainted?
I think that argument would be better served if there was less benefits to this plea. She received the dismissal of a second case in its entirety. She received the dismissal of habitual offender information, which wasn't an empty promise because she was still a second habitual offender, and a within guideline sentence. Now, coming from the prosecutor's office, we don't always have sentencing or plea agreements or plea bargains that have that much contained in one. So I don't know that she would have received a better bargain under these facts just because of the second or third habitual offender.
Do you agree with opposing counsel's characterization that all illusory pleas are a subset of unconstitutional, unknowing, and involuntary pleas?
I would say that an illusory plea would be an involuntary plea, but that a plea can be involuntary if it's not illusory, because as you know, the court rules set forth the standard for that. So if a defendant is forced by someone to plead, or is threatened by someone to plead, or promised something by their attorney that might not be set forth on the record, that could be an involuntary plea.
So you would accept the proposition that if we were to conclude it was in fact an illusory plea, that we would have to set it aside?
If this court concluded that it was an illusory plea, I do believe that this court would have to set it aside. But I believe that this court has already settled the definition of illusory in its Stovall decision. And in your Stovall decision in July of 2022, you said that an illusory plea is one in which the defendant receives no benefit. And the defendant really hasn't presented this court with any reason to overrule its Stovall decision today. Her argument in her brief focuses largely on the Michigan Court of Appeals decision in Stovall, but I believe this court has settled that issue, and receiving no benefit in exchange for the plea is completely consistent with how other courts, state and federal, have defined illusory. I want to address quickly the defense's argument that the onus is never on the defendant to raise this type of issue. Of course, mistakes were made in this case, and we don't dispute that. But just for the court to point out to the court, there is a statute, 769.13, that does allow the defendant a means to challenge an inaccurate habitual offender notice. Now, that could be before a plea or before sentencing, but that wasn't done here at all. And the legislature, by enacting that, has given the defendant the encouragement to raise any issues if the prosecutor did have a mistake like there was today, so that we can have fair plea bargaining with all of the knowledge surrounding this. And I do believe the defendant was in the best position to know her criminal history in this case.
Well, but it was a mistake also made by the prosecutor and unrecognized, and a mistake made and unrecognized by the judge, right? So doesn't it seem a little unfair to be saying, well, the plaintiff should have known what the prosecutor and the judge didn't know?
Yes, Your Honor, and I do say that mistakes were made here. And I don't think the issue is really for this court to determine how that happened, but to determine what happens now with respect to, can the defendant withdraw her plea, and was the defendant's plea voluntary and understanding? And as the Supreme Court said in Brady, we have to look to the totality of the circumstances. We don't just look at one facet of the plea. We have to look to the entire plea bargain in determining whether or not this was voluntary and understanding.
Where would you, so you agree it shouldn't be a per se rule, that it's a line drawing exercise that we need to do in cases. Can you give me an example of where you think, similar to that, where that line could be drawn?
Sure. So I think in some instances, there was a case that the defense cited in their brief, let me pull that up, where the benefits to the defendant, there were two offered. This was in U.S. v. Randolph. Two benefits were offered to the defendant, maybe even more than that. He received the dismissal of several offenses, but the prosecutor also agreed not to charge him with any other offenses arising out of the crimes that they knew of before sentencing. And then it went to a different state, still the U.S. attorney, and they charged him with those crimes. And in that case, the court said this plea agreement was actually to the defendant's detriment. It didn't benefit the defendant, so it was rid of a complete consensual character. So I think when we get to that point where we can't say this is no longer a consensual contract between the parties, then it could be rendered invalid.
So that, would it mean that any enhancement mistakes always just, no problem, defendant always gets a benefit? They pled down from something. So.
I don't believe so. People v. Bollinger is a good example of that, where the only benefit that the defendant actually received in exchange for his plea was the dismissal of the habitual offender information, or the promise not to bring one. I can't remember exactly. But on those facts, that was the only benefit that he was to receive in exchange for his plea. And I think even in cases where it may be a third to a second, if that's the only benefit, then we have to trust our trial courts to make that factual determination of if that rendered the plea involuntary. Did that significantly induce the defendant to plead guilty in those cases? And I think in some cases that would. So it has to be a case-by-case consideration.
So for you, your argument then is because there's so many other factors that went into this, it's not just the enhancement negotiation, but all the other things as well.
I think we have to ask the question, what was the nature of the misinformation at issue? Did this misinformation, is it possible that this significantly induced the plea? And did the defendant receive considerable benefit in exchange for his plea that would not deprive the plea of its consensual character?
I mean, it's a tough spot, though, to figure out what significantly induced the plea. I mean, obviously, multiple considerations, but it is hard to know, would the plea have gone differently had the proper facts been laid out at the time? And that's obviously our struggle.
Correct, and it's an abuse of discretion standard for the trial court, and we trust trial courts to make this type of balancing factual determinations all the time. You know, was a statement voluntary? Was a search reasonable? And we trust the trial court to assess the facts and to assess whether or not the facts in that case render a verdict for one or the other. So in this instance, I think we need to trust our trial courts to make that factual determination. And then, of course, it can be appealed, and the courts would review that on an abuse of discretion standard. The trial court is in the best position to be with the defendant when he or she is making the plea to determine, whether or not that specific facet of the plea bargain could have rendered that plea involuntary, or if that was a significant facet of it. The trial court is the one that's in those, not necessarily plea discussions, but they're the one who stands when the defendant stands before them and pleading guilty or no contest.
Isn't there also sort of a practical reality that the trial court experiences with lots of cases, and whether habitual notices are routinely dismissed or not, or routinely reduced or not, and whether a particular judge finds him or herself enhancing a defendant's sentence under habitual notices. And so the trial judge would be sort of uniquely in the best position to know whether or not going from a half third to a second, or a second to none at all, is a significant part of the plea agreement, or is sort of a throwaway add-on term.
I would agree with that, Your Honor. I think it may differ between counties, it may differ between judges, it may differ between prosecutors' offices, the types of offers. So
while it would be impossible for us sitting up here reading a dry record, not having any idea of what's actually going on the ground, to have a sense of that, the trial judge would be in a very good position to know that.
Correct.
One other thing Justice Kavanaugh asked about the sort of the misinformation and where it came from, and I just want for our audience to kind of understand how this works. I was a former trial judge. The trial judge does not have access to the defendant's prior record. The trial judge is dependent on what the prosecutor provides in the charging documents and the habitual notice, right?
Correct.
The habitual notice is provided to the defendant specifically to notify the defendant that he or she is being charged as a habitual offender and what that enhancement might be, right?
That's correct.
That's not a document that's stuck in a law book somewhere or in the middle of a file that never sees the light of day. It's provided to the defendant specifically to provide notice of the information provided.
That's correct, Your Honor.
Now, you've acknowledged the prosecutor here who has access to the defendant's criminal history made a mistake in the charging document. That's why we're here today.
Yep.
The only other participant who seems to me very likely would know how many prior offenses the defendant has is the defendant herself, who either was found guilty after a trial and convicted of the prior felony, or entered a knowing and voluntary plea to the prior felony. So at least in this circumstance of this case, and all cases aren't like this one, there's a lot of cases where the information is unequal, access to information is unequal, or involves complex legal determinations. Here that's not the case. Here we have two parties with equal access to the pertinent information.
Correct. I think a lot of the cases cited by both parties deal with a legal bar to prosecution that we wouldn't expect a defendant to know. I mean, maybe the defense attorney could help with that, but we wouldn't expect a defendant to know that like we would a defendant's criminal history. I see I'm out of time, so thank you, Your Honors.
Counsel, do you agree that the correct standard, you cited Lawson Court of Appeals case in your brief, and I believe counsel referenced the Hammond case from the Fourth Circuit that Lawson cites, but do you agree that the proper standard here is whether the prosecutor's mistake resulted in a grossly exaggerated the benefit to be derived by the plea? Do you agree that's the correct standard?
The standard that's cited in my brief and in the prosecutor's brief, Mabry versus Johnson, it's this United States Supreme Court case, is that the individual was fully aware, had a full awareness, that's the quote, of the consequences of the plea. This court embraced that requirement in Cole, full awareness, not some awareness, not substantial awareness.
If we think this is a grossly exaggerated standard is the correct standard, can your client win?
That a grossly exaggerated.
The grossly exaggerated standard from the Fourth Circuit in the Lawson case, if we believe that's the correct standard, does your client meet that standard?
I think everybody in this Opera House would agree with me that 2 years in prison is not slight and it's not insignificant.
Well, that's not what happened. The defendant didn't get an extra 2 years in prison. She thought she was being insulated against an additional 21 months, or 42 months, and instead she was being insulated against an additional 21 months. But she actually received precisely the sentence that she, actually 1 month less than her exposure that she thought she was agreeing to.
The prosecutor cited Santabello, I think, for the proposition that Your Honor is mentioning. And what happened in that case is the prosecutor agreed to a sentencing recommendation, and then when it came time for sentencing, reversed course. The judge on the record said that the prosecutor's recommendation in that case would have made no difference to him whatsoever, and the United States Supreme Court reversed.
I'm not sure what bearing that has on this case. If the judge here said that they weren't going to follow the sentence recommendation of the prosecutor, the defendant would have been entitled to have the plea withdrawn.
Well, what happened in Santabello was that there was a mistake or a mispromise that the prosecutor failed to keep up, and the judge said it would make no difference at all to him, and nevertheless, the United States Supreme Court said that's not a knowing involuntary plea where you were induced based on the prosecutor's promise, even if it would have made no difference to the trial judge.
No one here failed to keep their end of the bargain. That's the problem I'm having. I'm very much in line with the view that the defendant needs to understand exactly what they're agreeing to, and I was very careful as a trial judge in my colloquies to do all I could to make sure the defendant understood his or her rights and the contours, the full contours of the plea agreement. I'm very much in line with that view. I'm just not sure this case shows anything different.
Well, Your Honor, I just point the court again to Cole, where full awareness is required, and I know I'm out of time.
You're asking for a bright line rule here. I had asked the question of if the trial court had said at sentencing, I see that you only have one prior felony. This was, even if they say this was charged as a third habitual, but it's actually a second. I'm looking at the plea agreement and the range, and because it's a second, I'm going to sentence you to the low end of the range. Would you still be here arguing this case with the request that we have a bright line rule?
That might be better characterized as a sentencing issue. And I understood the question you were asking of the prosecutor. That feels to me much more like a sentencing error. And here we're saying that this mistake infected the plea itself. So in that situation, we might have two issues. It might be just slightly different.
But we have to look at all of the circumstances. I mean, you're asking us for a bright line rule that if there's any misinformation, the plea can be withdrawn. If we don't agree with that, how do we take this into consideration when we're looking at knowing and voluntary? Because to me, a defendant enters into that plea, they hear this range. Oh, there was a mistake. It was a third instead of a second, but it was being dismissed either way. And now the judge is even saying, I'm getting the benefit of that with the sentence. Do we take all of that into consideration if we don't have a bright line rule that any misinformation allows for a withdrawal?
I understand the question. It's very hard for me to square Cole that says full information is required with the idea that maybe some misinformation would be excusable. And maybe this is helpful, maybe it's not. In the civil context where there's a small issue in a contract, the remedy is to sue for damages, to make the individual who was wrong whole. In the plea context, when we're giving up rights to jury trial and someone's going to prison, there's no corollary. Plea withdrawal is the only remedy here. And so I think when we get into these conversations about small errors, maybe it's unfortunate that the only thing that can happen is withdrawing the plea.
Isn't that why we need to have a material breach of a contract?
Well,
before we give damages? In other words, small immaterial breaches. That's the whole question here, whether this is a material breach or an immaterial.
Yeah, I mean, you can sue for damages, but whether, what the judge is going to evaluate is what Justice Viviano has just said. And I think that's a discussion that we're having here. Mm-hmm. Is it any error, any minor error in the plea negotiations the per se rule would be withdrawal?
That's what we're asking for. I understand that there might be other cases where there are errors that are so minor that it's hard for the court to adopt.
But if we adopt a bright line rule here, that any error, then those cases, we don't ever have those cases come to us.
Well, when it comes to informing an individual of what the value is of the plea they're entering into, I do think that these errors are critical, and we'll never really know what's important to an individual. So an example might be that, you know, we'll drop a charge and we'll not request restitution, for example. And restitution to those of us in this room might not seem like the biggest deal when we're facing prison time. But if this person is a primary breadwinner for their household, they're going away to prison, they know they're not going to be able to provide for their family, and restitution really means the difference between the family being evicted or not, that could be a huge deal for that person. And so I hesitate to say that this court should allow judges who are not, of course, standing in the position of a defendant taking a plea and giving up constitutional rights to determine what was valuable and what was not. And it does have to do with the misinformation and the idea that the person was not able to make a fully informed, knowing calculus because of a prosecutor's error. And if the court wants to narrow the rule, it could be a prosecutor's error, right? That's the mistake. That's the kind of mistake we're concerned with here because of the enormous power that prosecutors wield. That's a way to narrow the rule.
Thank you. Thank you both. The case will be submitted and the court stands adjourned.
Morning, everyone. Please have a seat. It's wonderful to see you all here today at this beautiful venue. We're going to take just a second. We're going to set up back here, but before we do, I should introduce myself. I'm Dan Brubaker. I'm the Chief Commissioner. And before we get set up back here, I just wanted to say, as an attorney, arguing before any court can be a little bit nerve-wracking. Arguing before the Michigan Supreme Court can be particularly so. But doing that with hundreds of students staring at your back while you argue is kind of above and beyond the call of duty. So thank you. Could we get a round of applause for the attorneys here today? They did an amazing job, I have to tell you. That was a great oral argument. So we're just going to set up back here. Give me just a second. Can people hear me? Is that good? Okay. So before we get going, I just want to thank the justices for being here and to reiterate what Chief Justice Clement said on behalf of the Michigan Supreme Court. We are very thankful to the Cheboygan Opera House. This is a beautiful venue. We're just very happy to be here and thank the Opera House for hosting us. He just went to the back, but I wanted to thank my good friend and current 53rd Circuit Court Chief Judge Aaron Gauthier. Aaron was a commissioner at the Michigan Supreme Court. I had the chance to work with him for a number of years. One of the smartest guys I know. It was very hard to lose him, but I know that our loss has been this community's gain. And I also wanted to thank former 53rd Circuit Court Chief Judge Robert Butts and to all the other judges who were here, and the court personnel who worked on this and who took the time to be here today, as well as the student mentors and educators. So no one knows what the Chief Commissioner does generally, so just to explain a little bit about it, one of the things that I get to do as the Chief Commissioner is I get to sit with the justices during their conferences. It's one of the most interesting things about my job. And conferencing is what they are doing right now. They have gone back to a secluded room where they will discuss the case. They will talk about the briefs, they'll talk about the Court of Appeals opinion, they'll talk about the oral argument, the questions they asked, the answers that they got. And they will pick each other's brains about what they think needs to happen now going forward in the case and how the case should be disposed of. and they have a whole wide range of options open to them at this point. They could do what we call simply denying leave, which means they would decide not to opine on the case at all. And if they did that, the Court of Appeals opinion would stand. Or if a majority think that the Court of Appeals got it wrong, they could issue an order or an opinion explaining why they think the Court of Appeals got it wrong and reversing the Court of Appeals. Or if they think the Court of Appeals got it right, they could issue an order or an opinion explaining why they think the Court of Appeals got it right. If it was something really simple that they were doing, theoretically something could come out in a few weeks. If they decide to do an opinion, that takes longer. Someone could dissent. It could be months before we see something. So, and I have no idea what they're doing back there or what they're going to decide with this case. But I do know that all of the justices have given a lot of time and attention to the briefing, to the arguments, to the law, and they're thinking a lot about this case, this particular case, and also thinking about like how the rule that comes out of this case will impact other cases going forward. So we'll have a little more than 20 minutes, I think, for questioning. And I have some questions that I can ask the attorneys if the room goes silent, but I'm really hoping that that doesn't happen. Those of us that kind of take part in putting this together, including the attorneys here and the mentors and so forth, we all are very curious to know what your impressions were of what you just witnessed here today. We want to know what your questions are about what just happened. So I think we have a couple of people who will be passing a microphone around. So if you just want to raise your hand and feel free to ask any questions you have, or give us your comments or impressions about the oral argument. And so please don't be shy. If there's anything you want to ask, just go ahead and ask it. And I guess to begin, I'm going to kick things off. I'll start with the attorneys here. Usually when we're in court, the appellant goes first, which is the defense attorney in this case. So I'll just ask each counsel to introduce yourself to the audience and tell a little bit about your job and what you do. So Maya, we'll start with you.
Yeah. Hi, my name is Maya, and I work with the State Appellate Defender Office. We represent exclusively indigent or people who can't afford counsel. We're appointed by the trial courts to represent them in the trial courts on appeal. So here, that was the motion for plea withdrawal, which we filed in the Kent County Circuit Court. We represent clients in the Court of Appeals. And as you heard, there was a Court of Appeals argument and an opinion issued in this case, and then in the Michigan Supreme Court as well. So this is an example of Sato coming to the Michigan Supreme Court and arguing on behalf of our clients, most of whom are incarcerated.
Katie?
Hi, I'm Katie Wendt. I'm with the Kent County Prosecutor's Office. So I'm in the appellate division there, and there's 4 of us in the appellate division. And what we do is we largely handle anything that goes to the Court of Appeals or the Supreme Court. But we also handle any substantive motions in the trial court or any particular legal issues that come up during trial that our trial attorneys are handling.
Okay. Thank you both very much. And it is now time for the Q&A. So please raise your hands if you have questions.
And there's a microphone up here, too.
Hi, my name's Lyle. I'm sorry, but I had no idea what you guys were talking about the whole time.
Well, Lyle, it's good to be honest. We were talking about a situation where my client, Candace Guyton, entered a plea agreement, and at the time that she entered that agreement, one of the terms was incorrect, and it made the charges that she was facing look worse than they actually were. So she gave up her right to a jury trial based on information that was not complete and in fact that was incorrect. And so I'm here saying that she should have an opportunity to withdraw that plea. Anytime.
Hi, my name's Aubrey Benson. I'm here with Onaway High School. And I was curious if this is either of you, if this is your first time arguing in front of the Michigan Supreme Court.
This is my first time arguing in front of the Michigan Supreme Court. I've argued in front of the Court of Appeals many times, but this is quite the welcome to the Michigan Supreme Court being here.
It's a heck of a first argument. It is not my first
time. The defense at the original trial, they made the defense attorney, why didn't they catch this mistake? And why wasn't that part of your argument? That the defense attorney should have said, whoa, it's not a third habitual. I mean, why wasn't that part of your argument?
Well, certain aspects of cases can be discussed publicly. I will say that this is an error that doesn't need to be raised as ineffective assistance of counsel. That's an argument that we do make when we have to, but when there are cleaner arguments that don't require hearing, that are issues that raise reversible error or that present reversible error on the face with the existing record, that's a choice we make to raise one claim or the other. Sometimes we raise them in the alternative, but that wasn't done.
It's also a very high burden of proof to prove that an attorney was ineffective. You have to prove that their conduct fell below a reasonable standard and that their conduct actually prejudiced the outcome of the case. So it's a high burden for the defense to meet to establish that.
Hello, I'm Jeffrey Sabikdaroth from Magna City High School, and I have a question for the defendant. Do you have any say in whether a case is appealed, or is that entirely onto the defendant?
Does the attorney have any say?
Correct.
I'm sorry, I lost track of where the mic is. Hi. So, do we have any say in whether the case is appealed? Our job is to counsel the client about the risk, about the issues, about what might be successful, what might not be. If we are successful, then what? And ultimately, it's the client's decision to make. And that's very important to me and to our office, that our clients are fully informed, kind of a theme here, fully informed about the decisions that they're making and that they're empowered to make those decisions themselves. Great question.
Hello. So I had more of a question about the case per se. So I heard a lot of discussion going on about guidelines, and I was more so confused about the fact that I felt like we were dipping that they were dipping into a lot more of detail than I thought was really necessary. I don't really know how cases go, obviously, but I was just wondering about kind of that, and, well, in my opinion, I thought that this was kind of just going to be really cut and dry. I didn't know it was going to go into as much detail as it did, and like with the guidelines I had said, I was wondering if we were more so talking about if she wanted more so her her sentence reduced, or we were more so talking about the fact that she did have that was going to be her second offense opposed to her third, if that makes sense. I'm sorry.
So I'm not entirely clear on the question, but I'm going to try to answer it to the best of my ability. Largely, cases that reach the Supreme Court are not cut and dry. So cases that this bench is hearing are cases that are going to have significant implications for the state, and cases that they say that the Supreme Court is not an error-correcting court, so they're not going to necessarily say this was done improperly, so we're going to do something different. But they're looking to set a rule of law. They're looking to make sure that they are following the correct law. So when we get into the guidelines, that was a particular part of this defendant's plea that for both parties was very significant. For our side, it was significant that she knew the sentencing guidelines range. And what that means, if you're unfamiliar, the minimum sentencing guidelines range in this case was 51 to 85 months. So the defendant was guaranteed to receive a sentence between 51 and 85 months as her minimum term that she was to serve in prison. For the defendant, of course, it was very relevant because her guidelines, had she been a third habitual offender, which means this would have been her third felony as opposed to her second felony, her guidelines increase with the more felonies that she has on her records. Does that answer your question?
Yes, it does in a way.
I can also
the only thing that I was going to add about guidelines is that if the parties agree that the sentence will be within the guidelines and the judge says that he or she will go along with that, then the sentence would fall within the guidelines. But in the state of Michigan since 2015, the guidelines are not mandatory. So the judge can depart from the guidelines downward or can depart upward, but has to explain why. So that's just a little bit about the sentencing guidelines. I wish I had brought my manual, because there's this 200-page sentencing guidelines manual that you might love to page through that explains how the ranges are calculated for any given offense and all of that. It's available online, but don't bore yourself with it if you don't have to.
We have a question in the balcony.
Hi, I'm Aiden Jones with Gaylord High School, and I was just wondering how many months was she actually sentenced to?
She was sentenced to 84 months as a minimum sentence to 70 years? I think it was 7 to 60 years.
The maximum is high, I know that.
60 years.
7 to 60 years imprisonment.
Thank you.
Which means, by the way, that after the minimum term is served, she's eligible for parole. And she can interview with the parole board, and the parole board can decide whether she's ready to come home or not. Then, if she's not, or if they deny parole, then up until 60 years is when the parole board has the opportunity to release her. So in reality, for somebody who's a middle-aged person, that's, a maximum of life.
I was just wondering.
I was wondering, since there's only 6 justices today, I know we're missing one of them, how would they break a tie?
So in the event of a tie, first of all, I think the justice who's absent today may be voting on this case, and so we would have an odd number of justices voting. But if there were a tie, then the Court of Appeals opinion is affirmed.
It's called we would issue what's called a denial by equal division, meaning there wasn't a majority to do any one particular thing.
I have a young man that would like to ask a question. He got a little frustrated, so I'm going to let him go ahead.
No, I would never get frustrated. I was just wondering if she was putting herself at more of a higher risk by basically trying to, with the plea deal and everything, the fact that it minus out that other charge, wouldn't that count as a third offender charge anyways? So she'd be up to 3, or is that not how it works?
It's only prior convictions. So the fact of a pending case wouldn't subject her to a higher habitual offender notice.
No, but it wasn't a part of the plea deal that they basically forgot about that other case. So since the plea deal is no longer going to be active, would that mean that you would reopen that case, or?
So the timing of the prior felony actually matters for purposes of filing a habitual offender notice. What the risk she runs if that case was revived would be her, like we talked about, her guidelines. Her guidelines could potentially be scored higher because one of the prior record variables, which is one of the calculations that we have, takes into consideration a concurrent felony conviction. So that was one of the arguments that we were making today. From our standpoint is that she did receive a greater benefit because of the potential that you're talking about here.
Oh, perfect. Thank you.
This is Hunter, also from Gaylord. So I'm pretty sure she had a co-defendant in this case. So if she was the accessory and this kind of gets approved, does that kind of open up a new door for the actual accomplice to try and retrial something?
They're completely separate.
So completely separate?
Yep.
Okay.
I believe that her co-defendant has also pled, but don't quote me on that.
He did, and he received a lesser sentence despite having a prior conviction for armed robbery. So just leave that there.
Thank you.
It's Braylon with Inverness Academy, and I heard that she also got charged with her boyfriend, and that's kind of how they got caught. What about the boyfriend? What about his charges with her plea agreement?
Yeah, so that's the co-defendant who we were just mentioning. He did take a plea agreement, and he's been sentenced, and as far as I know, he's not appealed. But his sentence is significantly less than Ms. Guyton's.
So he's not getting as charged as much as Ms. Guyton's?
His charges were similar. I don't know his plea offer off the top of my head, but his charges were similar. His sentence, I believe, was 4 to 40 years as opposed to 7 to 60.
I was one of the student mentors, and one of the things that we explained to the students was there was another issue with regards to the use of an actual gun. And also, my question was where that fits into the sentencing guidelines, as well as the pre-sentence report that I would consider as a judge. It seems like I would say her prior record was, prosecutor said 22 misdemeanors, wouldn't it also have that prior felony? So the court, everybody in the courtroom's got the pre-sentence report. There was an error in that report as well. What's that impact?
Like I mentioned in my argument, the PSI did actually say one felony, so it's our position that the court and defendant was at least aware of the issue at the time of sentencing. Maya can talk to the other issue because I didn't handle this in the Court of Appeals.
I don't know if I understood the question, but you're absolutely right that we did raise a sentencing issue related to the use of a gun. The co-defendant we were talking about earlier had a plastic toy that he had taken from a Meijer store and held that out ostensibly to threaten or to, make the clerk at Popeyes think that he had a gun. And the guidelines are scored depending on the particulars of the case. So if there was a gun used, or if there was a knife used, or if there was just your fists used, or whatever, that affects the recommended sentence. And so we did raise an issue about that because it was only later discovered that this was a plastic toy and not an actual gun. But that's not an issue that the Michigan Supreme Court granted leave on, so we didn't get into that today.
Yeah, what happens is the court may look at, a party may raise several issues, but the court's order that's ordering oral argument might not necessarily ask the parties to provide further briefing on all issues. Sometimes the order will say, we just want further briefing on this issue. So the other issues are still alive. They aren't decided. But the court was more interested in getting further briefing and oral argument on the specific issue that was ordered in this case.
Hi, I'm Larissa Huffman from Mackinac City. Sorry. I was wondering if it was like a real gun compared to just the plastic gun, does that like change things with like the sentence and everything?
It changes the scoring of the guidelines, which sometimes could change the sentence and sometimes not. So that's kind of an unsatisfying answer maybe, but that's what it is really. It's just that the report that Judge Bunce was mentioning, that would reflect, if it had been done correctly, if the report had reflected that it was a plastic gun, our position is that Ms. Guyton would have been in a better position going into sentencing because a plastic gun really is different from a real one. But unfortunately, the report that the judge had at the time of sentencing did not say anything about the gun being plastic. It said it was a firearm, which probably to everybody here sounds really dangerous.
Hello. So nerves do take a toll how do nerves take a toll with the court or the arguments when you're presenting them up?
Did you ask how do nerves take a toll?
Yeah. So when you're presenting, if you get nervous, can that affect how your argument holds?
Of course. Yeah. I think every attorney will tell you they get nervous when they argue in front of a court, let alone the Supreme Court.
Yeah, I think practicing helps a lot, and you do it a few times and you feel a little bit better, and you do it a few more times, a little bit better. But I understand people have nerves. We all do. I just think preparation and practicing getting up in front of groups of people definitely helps.
One of the ways that people will prepare, and I'm sure Maya and I both prepare for this type of argument, is what we call a moot argument. So there will be people that sit and pretend to be the justices, and you actually give your argument just like we did today, and they pepper you with questions just like they did today. So that kind of gives you an indication of what types of questions you may receive and helps you practice answering the tougher questions that you'll receive for your position.
Hi, I'm Candy Hart from Inland Lakes Secondary, and I was wondering, because you were talking about, I'm sorry, I can't remember your name, the lady in the black. You were talking about how after this, she was taking a risk to add points to her court legal thingy.
Her guidelines.
Yep. Yeah, sorry.
No, you're okay.
I was wondering how the pointage system works, and I was wondering if you could elaborate on that, if you would.
Sure. So the Michigan sentencing guidelines that we've talked about take into consideration two different types of variables. Your prior record variables, which take into consideration your criminal history, and then offense variables, which are largely offense specific, and they look to certain factors that went into the criminal offense that we have. And we add up There's a book that, like Maya said, there's a book, and it shows you how to score points, and oftentimes we'll litigate whether or not points were scored correctly. And then once you get the PRV, which is the prior record variable score, and the offense variable score, there's actually a grid depending on the severity of the crime. You look to a specific grid, and then you plug in those points, and it'll say the actual guidelines for the case.
I was wondering what you meant by illusionary.
Say that one more time.
I was wondering what you meant by illusory.
Oh, illusory. Yeah. So that's a word that is in the legalese dictionary, and it means different things depending on which panel of the Court of Appeals is writing the opinion, which is the point that I was trying to make. I think it means that you enter into a bargain and one or more of the terms of the bargain are not real or fake. Think of the word illusion. I think that'll help.
So it's essentially an unfulfillable promise. Something, if we were to say, we'll dismiss the defendant's case for murder, but we had absolutely no legal basis to charge the defendant for murder, then that would be an illusory plea because it's a completely empty promise that the prosecutor can't fulfill.
Raven, you had a question up?
I'm Wyatt from Prescott Academy, and I was wondering if the 70 or 60-year sentence would be related to her other charges that I think she has, as opposed to just 70 or 60 years to an armed robbery charge.
It's just for the armed robbery charge. We dismissed the other charges, yeah.
Okay, I was just wondering about that.
I was just wondering how long it took to prepare for this trial, and second, was it the defendant's choice to take this to court, like the mistake, and then does it have any risks for her if it doesn't go through, or does it have any benefits if it does?
The first question was how long does it take to prepare? It's hard to put an exact hour or day on it because I've had this case for a long time. I think that I was just talking with one of my colleagues, and I think that the argument on the motion hearing for this was at the beginning of the pandemic. So I remember early days, using the laptop webcam, trying to get a good background to do this argument. So it's been a long time that this has been rattling around in my mind, and of course we all have many other cases, but Ms. Guyton has been my client for a long time now, so I've been thinking about this since I met her, and it was her choice to take this appeal. We don't do anything, we don't file anything, we don't make any claims without our client's approval.
I should mention the other factor that comes in, and the Supreme Court is a court of what we call discretionary review. There are very, very few cases that the Michigan Supreme Court has to hear. So we get, maybe 1,500 applications for leave to appeal every year of people saying, please take my case or hear oral argument in my case. But there's only a handful where we actually get to this stage. So it usually means the court has found something significant about the case or something interesting about the case where they want to hear more oral argument. So in addition to the defendant appealing, the court then has to grant what they call the oral argument on this case, which is not done very often.
I think to answer the last part of your question about the risks and benefits, I don't know if you caught it when Maya was arguing, but if the court sides with the defendant here and allows her to withdraw her plea, she's not required to withdraw her plea. She's required to be afforded an opportunity to withdraw her plea. So at that point, she'll be able to have those frank conversations with her attorney over what is the risk of this, what are the benefits of this, and actually make that decision then if that's something she wants to go through with.
We have 3 final questions in the balcony. Cindy Holmont, Bishop Erica. The defense lawyer, when you were asked by one of the Supreme Court justices, so do you think if mistakes are made at lower courts that all these defendants should have a right to appeal? And I believe you answered yes. Aren't you afraid you're opening Pandora's box in terms of the courts being filled up with all these appeals now?
I don't think we are. Like I said, only 3.5% of people who take pleas end up requesting appellate counsel. So that's one huge, 3.5%. Tons of people who are not even asking for a lawyer to give a second opinion. Then that 3.5% is reduced further because many people don't decide to take their plea up or try to pursue plea withdrawal at all. Some people try to pursue sentencing relief, so if there were sentencing issues in this case, which there are, but if we had only chosen to raise those, maybe we'd be here, maybe we wouldn't. And then, you know, a lot of times people don't even have sentencing issues and we want to raise court cost issues, for example, because they were charged too much money, right, at the time of their sentence. So I don't think there's a Pandora's box, but even if there were, this is people's liberty we're talking about, and the courts should be concerned with that, and they are. And so if there was more resources required to fund the courts so that people could have their rights vindicated, I would be all for that.
How did you get the Supreme Court to come to Cheboygan?
I didn't do anything. I cannot take any credit for bringing everybody to Cheboygan.
We just got a nice invitation to come here.
Yeah, but a lot of people who were on stage earlier before we started our argument put in a lot of effort to make it happen. So we have to thank.
I was wondering what the original charges were and how much that could make the sentence last.
So the original charges, she was charged in 2 separate cases with armed robbery, and the proper charge would have been as a second habitual offender. So the maximum sentence someone may serve for armed robbery is life in prison. But of course, the calculation of the guidelines, I don't know that anyone's actually going to serve their entire life because of this. But those were the 2 charges.
And I can answer the question before that. The reason why we're here is for former Judge Bub.
Yeah, the answer to the question of why we're here is that the court started this program back in 2007. There's been 27 cases argued throughout the state of Michigan, including the Upper Peninsula, and I happened to go to one at Lake Superior State University. Normally, there is a host court in a bar association and a host school. The uniqueness of this particular bringing the Supreme Court together was there wasn't a host school, like a huge 3,000 student school hosting it. I, on behalf of the Cheboygan area schools, asked the Supreme Court to come and present to all these smaller schools that should have the same opportunity that the larger schools do. One more thing I'm Judge Butt's course, student mentor again. Another thing that we talked to the students about was the fact that you had a lesser amount of time to argue today, 15 minutes each, because the court wanted you to convince them that they should grant you your claim of appeal. So just to make it clear, their decision today may be, we're going to allow these attorneys to come back again to the Hall of Justice in Lansing, as I understand it, and have 30 minutes apiece to again argue the same issues and possibly have a better chance to answer the questions of the justices. Is that correct?
Yes, that's correct. So what happened today is something that's we call it a MOA, but it's a mini oral argument on the application. So that's an option that the court has when a defendant or a prosecutor in some instances files an application for leave to appeal and essentially asks the Supreme Court to review the case. So a MOA allows the court to hear from the attorneys, have additional briefing without giving it that full grant of leave that we were just talking about, because very few cases are given that full grant. And this has been a good opportunity for the court in recent years to hear more from attorneys on some of the cases that they're on the fence with whether or not they want to grant leave.
We sometimes call MOAs grant lights. And the thought is, the court isn't exactly sure what it wants to do with it, but it wants to hear a little more about it and possibly grant leave afterwards. And so it's a great way. They're a little more flexible. You can get the parties before the court a little faster. The briefing isn't as onerous, and it's a great way to just quickly get more in-depth into a case without going into the full grant of leave to appeal yet.
Hello, I am Marshall of Iverness Academy. I had a question. Do you think this court case would change drastically, or we would even be here if it was like to her first, but they thought it was going to be her second offense.
I think we have the same argument. Yeah,
Okay.
good question.
So that is actually all I apologize, but that's all the time we have for questions at this point. If you were a little nervous about asking something, or if you didn't get you had a question and they didn't get around to you, feel free to ask the attorneys afterwards, and you can also feel free to go and talk to the justices, although you can't ask them like how they're going to rule on this case, but you can ask them other questions. So I just want to say thank you again, everyone, for attending. Thanks to our attorneys, Katie Wendt from the Kent County Prosecutor's Office and Maya Menlo from the State Appellate Defender's Office. Okay, and real quick, where are the Traverse City kids? Are there Traverse City kids here? Oh, there you're, way in the back. Thank you. It was a long way. Kudos to coming from Traverse City. I grew up there back in the late 1800s. It was a great place to grow up. So thank you very much. So what's going to happen now is we're going to move to the reception, but if you could just stay in your seats for now. Ushers are going to bring groups up one at a time to kind of come back. So thank you again. It was wonderful to be here. You're a great audience, and it was a great experience for everyone, I hope.